Hi everybody, welcome back to 10 Minutes with Griffin. I'm your host, Griffin Bridgers. For today's episode 133, we're going to continue our discussions on the basics of trust situs. For this part 3, we're going to dive into determining situs under state law. Now, as always, this presentation is not intended to substitute for legal or tax advice and is provided for educational purposes only. Now, as with the previous episodes, our goal is not to give you a firm conclusion where trust situs might be, mainly because this is different under most states' laws. Now, there are some general principles that are often universally applicable, be it common law and, increasingly, the Uniform Trust Code, but really what we're doing here is creating a framework to help you reach these conclusions yourself, to know where to look in your state's code and even in other states' codes to kind of settle this overall dispute. So as I mentioned, today we're concerned with the state law situs of the trust. So we're going to look at which state or states might have their own courts claim jurisdiction over the trust or its assets or over the actions of the trustee. Now, traditionally, situs was determined primarily by the trust instrument. That continues to be the case, and typically that situs will remain static until changed for some reason, typically by order of the court. Now, this causes issues. For example, if you have a trust created in State 1 and a successor trustee is appointed in State 2, is it fair to make that new trustee submit to personal jurisdiction in State 1? In most cases, it wouldn't be, depending on what applicable law says. Now, what is applicable law? Well, to mitigate issues like this, there's principles of common law and, increasingly, the Uniform Trust Code, which codifies common law and has been adopted in many states with some variances. And it's attempted to shift the situs determination from the trust instrument to more of the facts and circumstances of the case. Now, to start with, we're really focused here on Section 108 of the Uniform Trust Code, abbreviated UTC. And UTC Section 108 governs situs by determining the principal place of administration of a trust. Now, I have principal place in quotes because it's possible that administration could take place in many different states, especially now in a post-COVID world where we have a lot of virtual work going on by trustees and other people interested in the trust. So, principal place of administration is really going to be governed by some of the facts and circumstances we're going to look at here in a second. But to start, the UTC notes that this section doesn't preclude other means for establishing a connection with the jurisdiction designated in the trust. That's going to become important in a minute when we talk about specific forms of trust that may be situs dependent. So, what this means is that if you just simply state the situs or place of administration in the trust without adding anything else, then the UTC may come in to fill in the blanks. And those blanks, if not filled in by the UTC, could be filled in by the court or by common law principles because there's deference to common law under the UTC. And depending on the state, the trust can override some or all of the UTC principles by its express language. Now, there's some carve-outs that a trust can't change under the UTC, things like limiting trustees' duties and liabilities and things of that nature. And depending on the state, those may or may not include situs principles in terms of what cannot be changed under the trust instrument with respect to the UTC. Now, as I mentioned, this is an issue if the trust has a bare designation of situs or place of administration without further guidance. So, if there is further guidance of the trust, you look first to the trust. And if that guidance doesn't get you anywhere, or if there's a lack of guidance, then you look to the principles of Section 108. And 108 gives maximum deference to the trust instrument, but also seeks to avoid conflicts between separate jurisdictions. If, for example, you have multiple co-trustees or trust advisors in several states. And as I mentioned earlier, this is one of those areas where, because of remote work and a very transient population, especially in a post-COVID world, this is going to be a major issue that has to be addressed and could be litigated a lot more frequently than it might have in the past with respect to trusts. Now, the reason for that really kind of lies in the ordering rules that test the validity of any written designation of situs in the trust. One, and I want to emphasize again that this applies when there's no procedure in the trust for determining situs beyond just a bare designation of situs, or this applies when that procedure fails. So first, is there a corporate trustee? And if so, you look to the trustee's principal place of business. Is it located in the state designated in the trust? If yes, the trust is going to be respected. Now, in the case of an individual trustee, the question is whether the trustee is a resident of the state. If yes, the trust is going to be respected. And finally, if none of the above apply, then you have to look to whether all or at least part of the administration of the trust occurs in the designated state. If yes, the trust is going to be respected. Now, the big question on all of these is what happens if the answer is no? Now, before we get to that, there's some vague terms here such as resident of the state and part of the administration, and I highlight those because of their relevance to this post-COVID world that we're hopefully going to enter after we get everybody vaccinated or get things cleared up from a health perspective. But resident of the state is the technical language of the UTC. It doesn't look to domicile of the trustee. So it's conceivable that you could have a trustee who now works remotely and on the side serves as trustee and is maybe domiciled in one state but chooses to work remotely in another. Well, have you now opened up the trust to administration in that new state if that's the case? I also emphasize part of the administration because this could be as simple as record keeping for the trust. In other words, where does the trust original sit, in whose filing cabinet, and in what state do those trust documents reside? That could be part of the administration. So with a transient population, this is going to continue to be an increasing issue for a number of trusts. Now, I also want to mention in cases where it's a gray area where you don't meet those requirements, you look also to UTC Section 108B, which imposes a duty on trustees to administer the trust in a place that's appropriate to its purposes, to its administration, and to the interests of its beneficiaries. Now, as I mentioned, it's implied that the trust can go above and beyond just the mere designation of situs to put in additional language on the procedure for determining situs or the reasons for having situs in a particular state. Now, the big question is whether this trustee duty itself can be waived in the trust. Most likely it could to a certain extent, because generally what the UTC allows is for any trustee's acts or omissions to be waived either under the trust instrument or by the beneficiaries, other than just egregious conduct. So the two types of conduct that you typically cannot waive for the trustee would be conduct that's in bad faith or with reckless disregard to the trust instrument. Anything else is something that's waivable in terms of duty or conduct. And while this is an often unacknowledged common law duty to determine the appropriate place of administration and honor the settlor's wishes, it may be a good idea to address this in the trust. Again, going back to the UTC, especially if the trust is purposefully administered in a state where the settlor and or beneficiaries have no ties. And that would be the case with something like a domestic asset protection trust or an incomplete non-grantor trust. Both of those have purposes of asset protection, income tax savings at the state level, and they intentionally have to have a trustee who has the primary place of administration in a particular state with DAPT statutes or no income tax. And even further, going past that, the intent to create a DAPT or ING might enhance that duty to keep the trust being administered in that place. So overall, my general theme here is just be more explicit in the trust document, especially if there's an intent to create strong ties to the originally designated situs in a trust. Now, can you change the situs? Generally, yes, you can. UTC Section 108 creates a procedure for changing the situs of the trust. So generally, the trustee has the discretion to do so, but they cannot change situs without notifying the beneficiaries and giving them at least 60 days to object to the change in situs with the trustee and or the court. Now, if you can't get if there's anybody who objects, then you'd have to go into more of a judicial or non-judicial settlement of that situs dispute. But overall, what this does is it creates a system to change situs and create written evidence of doing so. Now, there's this weird conundrum where the status quo of the trust situs is presumed to be maintained until the trustee follows this specific procedure to change situs. And I see a number of trusts where this procedure hasn't been followed, and we typically have to go back to the trust instrument and assume that whatever situs is designated there still holds true, even if the trustee is located in a whole other state. So it's important to have a trustee follow this procedure where necessary. And it's also important to note here that this only applies to the current serving trustee. This procedure doesn't impose a duty on the trustee to notify beneficiaries where a successor trustee takes over and where trust property is turned over to that successor trustee, even if the successor trustee is located in another state. And speaking of that, when it comes to successor trustees, this is another area where situs often changes. So most of the situs changes and situs disputes I see stem from this appointment of successor trustees under the trust or under a trust procedure. So the goal here overall in any drafting project by an attorney is to avoid court intervention in the appointment of a successor trustee. And that's especially the case where there might be disputes about the situs. Now, if the trust is silent on the designation or procedure to appoint a successor trustee, then first you have to look to the beneficiaries and have them unanimously appoint a trustee. That's a principle under the UTC. And if you can't get that unanimous consent, then the court, which is determined under the Situs and UTC principles, would step in to appoint a trustee at the petition of either the existing trustee or beneficiaries. So obviously the court issue is one you want to avoid, but even more onerous than that is the requirement of unanimous consent by the beneficiaries. So as I mentioned, the UTC fills in blanks where the trust is silent or where trust procedures failed. So what you want to make sure you do as a good drafting tip is to make sure that you don't have to rely on unanimous consent of the beneficiaries. You can get around that drafting. Now, finally, the way the trust is interpreted is different from where it's administered. So we have two sets of laws that apply. One is the law governing the administration of the trust, and the other is the law governing the interpretation of the trust's terms and provisions. So the latter is known as the governing law, and the governing law will typically remain static, but this can also create disputes between the state of creation of the trust, which is typically the state whose laws become the governing law of the trust, and the state where the situs might be at any particular time. Because if there's any dispute on the trust, if governing law becomes an issue, it's where a court in another state is trying to interpret a trust based on the laws of its governing state. So one big universally recognized rule here to note is that under common law and the UTC, typically, the courts will look only to the four corners of the trust instrument unless there's clear and convincing evidence of either an ambiguity or a mistake. So, where you often see a governing law issue come up is if there's ambiguity in the terms of the trust and how they might be interpreted or applied. So, it's important to make sure that good drafting, once again, saves the day when it comes to both the governing law and the law governing the place of administration of the trust. As always, if you have questions or topic suggestions, you can email those to me at griffin.bridgers@gmail.com. But thank you again for joining me for this episode of 10 Minutes with Griffin, and I look forward to seeing you in the next one.